You're listening to the Final Say Radio Show, a Rappaport Media production, with your host Brett Rappaport and co-host John Rappaport.
Andrew Walker is a policy analyst with the Heritage Foundation, and of course, you could find his work and all the work of the great experts and analysts at the Heritage Foundation at heritage.org. Andrew, welcome to the program. This is Brett Rappaport.
Brett, it's great to be with you. Thanks for having me.
Well, I appreciate you taking the time, especially on such short notice, but this is such an important decision, especially for those of us who are very strong believers in not only in traditional family, but in traditional marriage. And I think it's important to find out from you a couple of the significant key aspects that come from the decisions on marriage in DOMA.
Yeah, well, I'm glad to explain them. So the Supreme Court heard two cases in March, and today they announced their rulings. The cases were on Proposition 8 and the Defense of Marriage Act. And to be brief and somewhat summarize them, the rulings today indicate one big major principle, and I'll discuss the more minor specifics in a second, but the big principle is that the ability for Americans and their elected officials to make marriage policy democratically and constitutionally is now it's a bad move today as a result of the rulings. In the Defense of Marriage Act case, the Supreme Court struck down Section 3 of DOMA, which defines for federal statutes and for federal laws the definition of marriage, which was between a man and a woman, and defines what a spouse is. And they decided that it was an undue burden on the states that have same-sex marriage, and that there was kind of a natural inequality between federal and state. And so they struck down the federal definition and are going to ostensibly be giving federal benefits now to same-sex couples who reside in states that have same-sex marriage. On the Proposition 8 case, they actually dismissed the case outright, saying that the proponents who came forward to defend Proposition 8 lacked the proper authority or proper standing to defend the law, and more or less throughout the case and the lower court rulings in the federal district court stands, which struck down DOMA. So today is a problematic day in America for sure. Citizens in California who went to the polls twice to vote on their definition of marriage between a man and a woman have had their voice taken away from them. And then likewise at the congressional level and for federal purposes, the Supreme Court decided that it is unconstitutional for Congress to make marriage policy.
Yeah, it's very troubling to me. I mean, you could see where the argument could be made from on a constitutional grounds that, you know, other people have a right to federal benefits. But I think for me, where it becomes very problematic is the fact that, one, I don't think the Supreme Court should ever be writing law. And in this case, it seems to me the Supreme Court is defining marriage. And that, to me, was, if anyone was going to do it, should be either voters in a district in a state where, you know, the 10th Amendment allows for states to decide how a state will view law, or Congress. And I think in this case, we're not seeing that at all.
Yeah, that's partially correct, yeah. Thankfully, the one silver lining in today's ruling is that the Supreme Court did not find a constitutional 50-state right to same-sex marriage. And that's exactly what the proponents were advocating for. Ted Olson, who was the lead attorney, went to the Supreme Court saying, I'm going to find a 50-state solution to same-sex marriage, and I'm going to have the court find it. And he did not. So in the one sense, we're happy that the Supreme Court did not overturn the 38 other states that have either a constitutional or statutory amendment defining what marriage is. The problematic thing about this, though, is that they have federalism wrong, which is what you just talked about with the 10th Amendment, powers delegated to the states. Well, they actually kind of have this pseudo-federalism going on that says now the federal government has to listen to the states, when in reality there's that proper balance in federalism. Federal laws are for federal laws, state laws are for state laws, and one shouldn't dictate the other. But in this particular, go ahead.
Yeah, I'm sorry. I was going to say that's a great point.
Yeah, and that's exactly what this is about. So we have kind of a pseudo-federalism case going on. Now the states dictate to the federal government what their marriage policy must be, which just gets it wrong. So again, and they do this at the great harm of self-government. I mean, at the heart of America's founding was the idea that we vote democratically, we have our voice heard, and now that has been, the rug has kind of been taken from underneath citizens and from elected officials who are doing things appropriately and constitutionally and by the rule of law.
What's the next step in this process? Now, one part of this case or one of these decisions is going to bounce back to the California courts, but what's the next step in California?
Well, that's a great question, and to be honest with you, we don't know.
Do we even have that answer?
Well, I was going to say, we don't know the full scope of the Prop 8 decision beyond the plaintiffs, because some people think, well, the ruling by the Supreme Court on Prop 8 it's only relevant to the plaintiffs, so it would just be the two gay couples that would be able to get married. Others are saying, no, this is because they dismissed the case outright, this applies to all same-sex citizens in California would now be able to get married. So that's another issue we're still waiting to hear. So it's a good question.
Now, I heard somebody say that the plaintiffs in that case, and I only heard this, I didn't read this yet, didn't have the standing to bring that case because I believe the original filers didn't pursue it any further. Now, if that was the case and they didn't have the standing, that means that the original filers would be able to refile, I suppose. So I guess there's a lot of complications here that we just don't know.
Yeah, no, that's exactly right. And our Heritage legal team and John Eastman, who's a legal scholar and the chairman of the National Organization for Marriage, we're all still kind of weighing the options and what's to come out of this because as you've noted, there's not any specifics yet to be known.
Yeah, this is just a very interesting thing. I had a couple thoughts here. One, which I think would be considered extremely controversial, and that's for the unintended consequences of people who pursue things such as gay marriage that ultimately, when they get them, I think in the long run may actually be bad for people who are gay. And I'll give you two examples. One is, I think as gay people, if they get married and eventually go through the process of divorce and having to deal with splitting up assets and all the other wonderful things and paying lawyers and, things of that nature, they may not view marriage as such a great thing. And, just for some of the things that if things go wrong. Mm-hmm. But the other thing is that, and this is where it definitely gets a little controversial, is that if you're going to have gay marriage, I think that ultimately it'll lead to fewer gay people in the population. And I think that if you subscribe to believing that, people are either, however people come about being gay, it doesn't really matter. But if you subscribe to the fact that if gay people have something within their makeup and then they have children, that some percentage of future generations will be gay. But if gay people are no longer marrying people of the opposite sex and having children, there's a possibility that future generations will have much lower numbers. And I think now it's just a very different thought that I had this morning when I was thinking about this, because I always try to look at different angles and what are the unintended consequences of sometimes getting your way. Yeah. And I think it's something to think about. You don't have to comment on that. I know it's a...
Well, I can tell you one of the unintended consequences right now is, if we move ever closer to the state stepping in and defining what marriage is, we're basically giving marriage over to the state and allowing the state to define marriage according to any premise that it wants. And so from our concern as conservatives, that if marriage is no longer based on the complementarity of the sexes, why is marriage then considered to be monogamous or exclusive? So you begin to raise all these open-ended questions of, okay, if marriage is no longer based on man and woman, why is it only based on the number two? And then why do we base marriage on the idea that only two people ought to be together? So there is some legitimate concern about if a state wanted to pass a polygamy law, would the federal government then be forced to recognize a state-based polygamy law because the states now, according to the ruling today, trump more or less the marriage laws in this land. So there is great concern, and there's unintended consequences that we still don't know about yet.
No, that's absolutely right. And I think one of the biggest problems I see that we haven't even brought up, but just in the last minute I have with you, is that when you start making radical changes like this, we've had arguments about church and state for decades now, and that's been a highly not controversial, but highly heated on both sides. You know, one defending, one on the opposition. And to me, I think when states where the government starts taking over marriage and taking over family, I think that they're further eroding religion and the role of faith in the family makeup and in marriage. So I think that's something that'll become, I guess, part of this controversy.
Yeah, and I'll just end by saying that's exactly right. And one of the great concerns we have is, you have increased, you have same-sex marriage happening across the nation, and then you have the rise of anti-discrimination ordinances, and where those two meet, they bisect or they intersect with religious liberty and religious expression. And so there are many cases that are happening almost on a weekly basis where someone is being forced to violate their religious liberty to participate in a type of wedding service that is against their faith. And so you see a Colorado baker who's being forced to use his creative services and his artistic expression to make a cake for a same-sex wedding, which he does not agree with, and now he's facing potential fines and penalties in Colorado. So you're right, there is a definite harm to religious practice and expression as same-sex marriage takes root in America.
Well, fixing one supposed discrimination often leads to others, and we definitely see that in this case. Andrew Walker with the Heritage Foundation, I want to thank you so much for taking your time, and thank you for educating us on some of these very important issues regarding marriage and the decisions by the Supreme Court case.
All right, thank you so much. Appreciate it.
Okay. Thank you again,
bye-bye.
Andrew.